Welcome to the NYU Law Forum. I'm Katrina Wyman, a professor here at the law school. And today we're going to be talking about fighting climate change in an age of opposition. And we have four great panelists to help us. I'll just very briefly introduce them. We have Neela Banerjee, who's the head of the chief climate editor at National Public Radio. We have Professor Ricky Revesz, professor here at the law school, former dean of the law school. We have Cesar Rodriguez Garavito, professor here at the law school and head of the More Than Human Rights program and the Terra Clinic. And we have Jake Werksman, who's a senior fellow here at the law school this year. And when he's not here, he's head of delegation for the European Union to the Paris Agreement and United Nations Framework Convention on Climate Change negotiations. So without further ado, we're going to start the discussion. Basically, the format for today is we're going to start with a conversation up here, and then we'll open it up to questions. And if you have a question when that point comes, please remember to come to the microphones to ask your question. Okay, so my first question is going to be for Neela here. And my first question is really, you have a kind of bird's eye view of climate news. And so I'm really curious here, what do you think are the most important developments concerning climate change in the past year or so? And are they all negative, or are there also some bright points that you can point to?
Right. So clearly, So clearly this was, like we were just discussing this even before everything began. First of all, thank you for having me and for having this panel. I think a lot of things are probably pretty evident to anybody who's following climate change. Last year, our reporters at the beginning of 2025 had plans for projects that they needed to do, and then DOGE came along and that blew up everything, not just for climate reporters, but for just about any reporter. So obviously, the very ambitious and aggressive rollback of climate policies under the Trump administration is one of the biggest stories. But it's also not been an unfettered march, right? There's a lot of push and pull, a lot of cases that they're losing in court, then they appeal. And so what it's created is a lot of uncertainty. And one of the things that we see in the climate space is something that you see elsewhere, like say in US relations and with other countries and diplomacy. And that is that the United States government is becoming an unreliable partner, whether it's to a little community in Nebraska or whether it's to our diplomatic partners overseas. So that is something that we're seeing in the climate space, and we're seeing this kind of push and pull. Some of the other stories that we're working on is about, I felt like for a long time there's this false dichotomy between doing something for the environment versus doing something for economic growth. And I think regular Americans are starting to see how false that is, because home insurance prices are going through the roof in this country. And we and other media are covering this too, and will continue to cover it. So climate change is definitely coming home to people's budgets and forcing hard choices on people, even if they've not been hit by extreme weather yet. Climate change in public health is another thing that we're following. We have reporters assigned to this. And then finally, and we continue to follow climate science and what's being done or not done. And sometimes, you do reporting and it actually changes things, right? Like one of our reporters did a story about NASA, about the Defense Department no longer sharing data with NOAA on real-time data on storms. And after that story came out, they were doing it rather quietly. The Pentagon reversed its decision. So we continue to work on science. And I think the other thing that we continue to work on, we can talk about this at greater length, are climate solutions. We have a dedicated solutions reporter at NPR. This year will be the fourth year that we have a Climate Solutions Week. It'll be in the spring. And what we focus on are things that, especially the communities are doing in the States and overseas, in light of the pullback by the administration. And you'd be surprised the action that's going on. I'm in the process right now of reviewing pitches that we've gotten. We've gotten like 70 pitches from all over the country and all over the world from our member station reporters. And the things that are happening in communities that you would not expect, they're not blue bubble communities, are really eye-opening. And so that's what I would say is that it gives me a sense that regardless of what the administration thinks, there are a lot of people, also regardless of their politics, who are taking extreme weather seriously.
Okay, let me move on to Ricky, picking up on something that you mentioned, the rollbacks of regulations. So last week, the Trump administration rescinded the endangerment finding. That's a predicate for regulating greenhouse gas emissions under the Clean Air Act. So you want to just describe what that rescission means and what is the significance of that action?
Sure. So on Friday, EPA posted its final rule, and as Katrina said, rescinded the finding that greenhouse gases endanger public health or welfare. This is a predicate for essentially all climate change regulation under the Clean Air Act. The main rules that it affects are the vehicle emission standards, which were part of the same rulemaking proceeding, so those were expressly repealed. But it's very likely to affect the power sector standards. That rule has not yet been finalized, but it is likely that when it is finalized, we might see a reference to the repeal of the endangerment finding. And also, in the third big climate rule under the Clean Air Act is a regulation of methane emissions from oil and gas installations. There's a fourth rule that actually will prove to be an embarrassment to the administration, which is a regulation of greenhouse gas emissions of aircraft. And that will prove to be an embarrassment because with the fall of the endangerment finding, it may be that U.S. airplanes will not be able to fly to foreign countries. More to follow on that, but keep an eye on it because it would be profoundly embarrassing. So EPA had proposed a rule that made basically two arguments. One argument was that greenhouse gases were not air pollutants for the purposes of the Clean Air Act. And the second was that even if they were air pollutants, the science behind climate change had evolved so that climate change was no longer as bad a problem as it had been thought to be. This is, by the way, completely preposterous. In fact, all the science has gone in the opposite direction. But this is what they said. And in order to support this, they put together a group of 5 climate skeptics housed in the Energy Department, and they did their thing. The work they did was so profoundly embarrassing that even by the standards of this administration, they could not rely on this work for the final rule and dropped any argument that climate change is scientifically not as bad anymore as it used to be. That was dropped, and it was really a remarkable confluence of great work by litigators. There was an action brought by EDF and the University of Scientists, arguing that this group violated the Federal Advisory Committee Act, and as a result of that, they got lots of discovery of documents. It said things like EPA political people telling these supposed scientists, you have to write this in your report, you have to get it done in 2 weeks, you have to do whatever. So that was all dropped. And then civil society played a role. The National Academy of Sciences quickly put out a very good report excoriating the Energy Department. Major scientific organizations filed comments in the notice and comment rulemaking. So now we're only down to legal arguments. The legal arguments are actually as bad as the scientific arguments. The first thing that EPA says is that when Congress enacted the Clean Air Act of 1970, it focused only on local and regional pollutants and not on global pollutants. It turns out there's a fairly voluminous legislative history suggesting the opposite. I actually had written an article about this, an academic article, 6 years ago. They completely ignored all this stuff. They also completely mangled Massachusetts EPA, which is the leading case in which the Supreme Court held that under this particular provision of the Clean Air Act, greenhouse gases are air pollutants. They somehow, I mean, you know, if a first-year student wrote this in an exam, I mean, you know, it would be bad. It would really be bad. And they mangled 2 other Supreme Court cases in similarly egregious ways. And they do all kinds of other things. You know, if you read the reporting on this, one of the things that you could see was that like, the president announced it in the Oval Office, or maybe it was the Roosevelt Room, I think it was the Oval Office, and there were like these posters that said 1.3 trillion. So 1.3 trillion was a number that the president said, $1.3 trillion the president said will be saved as a result of this repeal. It was based only on the fact that electric vehicles are more expensive when you purchase them than internal combustion engine vehicles. It completely overlooked the fact that under EPA's own analysis, in its regulatory impact analysis, the additional costs suffered by consumers are between 1.4 and 1.5 trillion dollars, and this is an out-of-pocket cost. You don't see that in any Oval Office poster, but interestingly, you also don't see that in most of the news reporting. The 1.3 trillion number got a lot of attention. The larger number on the other side got almost no attention at all. And in addition to that, guess how much the administration attributes to the harms of climate change, both the health harms in the United States and the global impacts? Zero. The health harms in the United States are about 4,500 deaths a year. They give it no value at all because a few weeks ago, EPA decided it was no longer going to either quantify or monetize any public health impacts of any environmental regulations, even though the Clean Air Act is, under the Clean Air Act, even though the Clean Air Act is primarily a public health statute. And they don't attribute anything to the climate change impacts of greenhouse gas emissions because the president, in his first day in office, withdrew the estimate that had been prepared through a very full scientific process by EPA in 2023, setting a number. So this, and what I've told you is only the tip of the iceberg of the legal problems with this rule. And one of the frustrating things is in the way that these things get discussed, there's, the administrator said this is like, what the law requires. Some professor says, whatever. And it's all presented as like, okay, there are two hands, we have no idea. This is not plausible. This is an embarrassment. It's profoundly embarrassing that the US government will produce work of this abysmal quality.
So I think that's all super helpful. And just for people who want to follow up, he published an op-ed in Bloomberg kind of outlining some of the arguments he just made.
Yeah. And I just submitted another one this morning. So, and one of the things I also is I'm the faculty director of the Institute for Policy Integrity, and some of my colleagues, including Kate Weldy, who's here, also has a piece coming out. I think we have 5 different pieces on different aspects of this, and each one is equally embarrassing for the administration.
And so this could be the subject of student notes as well. Thinking about strategies,
yes.
things you can do. In
I see lots of my students here. Never ending.
Exactly. Okay, so moving on to Jake. Jake, the EU's been a real leader on climate change, but even the EU, which has a very elaborate policy framework, which I've often envied from across the pond here for addressing greenhouse gas emissions, even the EU seems to be moderating somewhat in its commitments, as judged by the difficulty the EU had coming up with its latest nationally determined contribution, the use of foreign credits to help you comply, and delaying the implementation of emissions trading for heating and transportation fuel. So I'm wondering, do you agree the EU is moderating? And if so, why? Why is the EU kind of encountering? What are some of the issues the EU is encountering in addressing climate change?
Thanks for the question. I mean, I think I would start by observing on this word opposition, and the way in which the panel is framed is that this opposition is new, and I think it's important to reflect that opposition to climate action is not new. There has always been resistance to transitioning away from fossil fuels. The interests that are vested in this country and economies around the world in a continued dependence on fossil fuel is real. And so anyone advancing climate action and climate policy is always confronting a degree of opposition, and the challenges, of course, in trying to find the arguments that are sufficiently persuasive to tip the movement in the other direction. I think the EU, at a height in which there was broad public support for action on climate change and broad support from the member states in terms of the political alignment of various governments, took a very important step in legislating at the EU level a climate law, which requires the EU to be net zero in its emissions by 2050. and then built into that the kind of science-based decision-making, I guess that's in the Clean Air Act as well, to make sure that we're making decisions along the way that keep us on that pathway to net zero every decade. The way in which policy develops in the EU is that the European Commission, where I work when I'm not enjoying a fellowship at NYU, has the obligation and the power to initiate legislation. And under the climate law, we have to follow scientific advice from an independent board, which tells us what Europe's pathway needs to be consistent with climate science, but also with this net zero obligation for 2050. And that's where the proposals for 90 to 92% emissions reductions from the EU by 2040 came from. And that was the point at which the member states began to sort of say, wow, that seems like a lot. To imagine our economies individually and collectively being that far off where our emissions were in 1990 and that close to net zero within a few decades seems quite daunting. The legal obligation is there, so there's a limited amount of wiggle room, but nonetheless, there was a pushback. I think what's important to observe is that the EU has essentially stayed the course. The proposal from the Commission to be at 90% below 1990 levels by 2040 is surviving. It's about to pass the co-legislatures, the Council, the European Council of Ministers, as well as the European Parliament, and that will then itself become binding law within the EU. All the then implementing legislation that's necessary to get us there will follow as a matter of course. But there's no question that the EU, even when staying the course, politically is hesitating about the consequences, the economic impacts, the social impacts of that kind of a transition and within such a short period of time will have on the EU and the EU economy. And this requires the champions of climate action to begin to develop rationales for that transition that aren't just about making a fair contribution to avoiding dangerous climate change. And this is what you're now seeing is becoming much more of the political discourse in the EU, not so dissimilar to the questions about the costs and impacts in the United States. But two additional pillars have essentially been added to the EU policy arguments. One, thanks to the illegal invasion of Russia by the Ukraine and the exposure of the dependencies that we had on Russian oil and gas, is the argument about the need for energy security. Absolutely essential, and I think that resonates with politicians that might otherwise resist a purely environmental-based argument. The transition away from fossil fuels and towards renewable energy will give the EU an energy security and energy dependence that it didn't have previously. And then the third pillar is about competitiveness and the need to be part of the transition that's happening across the world towards renewable energy in a way that promotes European industrial growth, promotes European innovation in technologies, and this is, I think, becoming very persuasive as a third argument as well. And the shame is, of course, in terms of the transatlantic relationship, is I think a lot of these ideas were taking hold in the leadership of the previous administration, but now are being flipped on their heads. The argument is now the science is bogus. The argument is now that this is not the route towards economic prosperity. And so an ally that we've had in the past, at least for periods of time, has now become that unreliable partner that was referred to before, at least with regard to the fight against climate change.
Does anybody want to kind of comment on what Jake just said? No, at this point. Okay, can I just, Jake, before we move on, I'm kind of putting you in the role of representative for the rest of the world here. Can you just talk a little bit about given your vantage point from the international negotiations, what do you see China, the leading emitter right now? So just for people in the audience, China is the leading emitter on an annual basis. The US is number 2. Then number 3 is India, and the EU is number 4. So what do you see, what position do you see China taking right now in climate policy at the international level?
Well, I mean, China, like the EU, is one of those, I think it's 75% of the countries on the planet that is a net fossil fuel importer. And so it also has an economic interest generally in transitioning away from a dependence upon imports of fossil fuels. And so it shares that insight with the EU. It, of course, has, for many decades, been, it seems, anticipating and investing in China's prowess in delivering the clean energy and the clean technology that are necessary for this transition as well. So in addition to wanting to be less dependent on fossil fuels, it wants to create and to supply global markets in PVs, in electric vehicles, in wind turbines, in batteries, eventually in green hydrogen, and the technologies that deliver that as well. So its position in the negotiations is very much one that is supportive of the transition away from fossil fuels in self-interest, but at least they state that they also have a concern for the global environment and avoiding dangerous climate change, and for the multilateral rules-based system that they've committed to by signing up to the Paris Agreement as well. I think they feel very comfortable in that multilateral environment because it's one that they designed together within the US in such a way that doesn't scrutinize the individual level of ambition of any party to the Paris Agreement. And any scrutiny of the Chinese latest nationally determined contribution or target under the Paris Agreement would show that it is woefully inadequate as a country that is a source of currently 30% of greenhouse gas emissions to contribute seriously to the Paris Agreement goal of avoiding 1.5 degrees.
Okay, helpful context. So now, Cesar, I wanted to bring you in to talk about some of the recent judgments from international courts and tribunals. So we're at a law school, so we tend to focus on these things. So in the past year or so, we've had judgments from the International Court of Justice on countries' obligations in relation to climate change, also from the Inter-American Court, and also from the International Tribunal on the Law of the Sea. Maybe you want to start with what are some of the main things coming out of those judgments that you think, or in particular the International Court of Justice or the Inter-American Court, that you think could be useful tools for helping to fight climate change domestically?
Sure. I also feel the need to offer a bit of a hopeful story, given that there are lots of students here, and definitely there's good news in the rest of the legal world, partly because what the ICJ did and what the Inter-American Court did last year was the consolidation of really like 20 years of work, hard work by advocacy organizations, litigants, courts from around the world. The idea that a country would be held liable for not doing enough against climate change and would be mandated to, say, increase its mitigation targets was laughed at 20 years ago. I wrote a whole book telling this story, and I interviewed some of the litigants of those early cases. The very first case of this type that was based on human rights arguments was filed before the Inter-American Commission of Human Rights in 2005. When I interviewed the lawyers for that case, they said that their colleagues thought they were crazy. The big human rights organizations were very skeptical back then about the framing climate change as a human rights issue. So fast forward 20 years, exactly 20 years, and you have the Inter-American Court of Human Rights holding 3 different big hearings in Barbados. We participated in one of them in Barbados, 2 in Brazil. Then the ICJ came down with a decision, an advisory opinion that was more assertive than anyone would have ever imagined. I mean, if anyone says that they were hopeful about the ICJ saying what it said, I think that they would not be telling the truth, because no one imagined that the ICJ would be spelling out hard legal obligations the way that it did. The way I see this, and these are big judgments, each one is hundreds of pages long, so I won't go into the details, but I want to lift up a couple of key takeaways from those rulings or from those advisory opinions. One is that what these courts did was integrate a whole lot of international legal frameworks. One of the, of course, the disadvantages and the complications with international legal regime when it comes to climate change is that it is highly fragmented. You have international human rights obligations, then you have the climate obligations, you have the Paris Agreement, and so on. So both courts and also the ITLOS court did a really good job at integrating all these regimes and clarifying for the world, especially for states around the world, what they need to do according to the statu quo in the international law. Then the second thing that those courts did was skillfully spell out the level of bindingness of those obligations. And this is quite important because it means that we moved from a largely soft law world to a hard law world where both courts said that it is not optional. It is not optional for states, say, to pursue efforts at decarbonization that keeps the planet at 1.5 degrees of global warming above pre-industrial levels. That is no longer a choice as per international law. Likewise, the strict duty to regulate the production and the consumption of fossil fuels. That's also a hard international law obligation. Similarly, if you go down the list of the key tenets of the international climate regime, that what I just described has to do with mitigation, bringing down emissions. Adaptation, meaning the need of many human communities and ecosystems around the world to adapt to the already inevitable changes that global warming has brought about, meaning the floods, the high level, the rising of sea level, the heat waves, and so on. That issue of adaptation has gotten much less attention from courts and from litigants than mitigation. In our country, we've done a study of all of the decisions based on human rights that courts around the world have handed down, and about 90% have to do with mitigation. Only 10% have to do with adaptation, which is why it was significant, especially in the Inter-American Court of Human Rights decision, that it gave a lot of attention to adaptation and the obligations that states have to help communities, help individuals adapt to the effects of climate change. So going back to your point about the economic cost, but also the non-economic cost, the cultural cost, the human cost of human communities, for example, having to move from one place to another because their houses are no longer viable, their place of their communities can no longer be located where they have been located for the longest time. And finally, and this is kind of the last takeaway from both decisions, and this is pretty clear in the ICJ decision, that providing some sort of reparation to those who have done the least to produce the problem, to cause climate change, and yet are suffering the worst consequences of climate change, countries in Global South, in small island nations, and so on, that too is a hard law duty. Just to end on a socio-legal note, we now stand at an interesting moment in climate litigation history, where we have the law that all of the litigants and many of the courts would have dreamed of, right, 20 years ago. It's hard to get something more assertive than what the litigants got and many of the small island nations that push for those judgments got in both decisions. And yet climate politics is pulling in a different direction. So the gap is now more abysmal, more spectacular, and one of the challenges going forward is going to be how to leverage the letter of those decisions to help close that gap.
Can I just ask you, Cesar, which countries do you think that these international legal arguments are most likely to be open in their courts to these international legal arguments? Like, where do you think these international legal arguments are most likely to carry force? I don't tend to think of the US as a jurisdiction where these international legal arguments are going to carry a lot of weight in court.
Yeah, probably not for reasons that we've heard about in this panel. I would think that Europe continues to be a place where many of the most innovative legal actions are filed. Some of the most interesting cases, and we can talk about that more later if there's interest, are happening in jurisdictions like France or the Netherlands or Germany. Also, some of the cases are going all the way up to regional courts like the European Court of Human Rights, which handed down a landmark decision last year against Switzerland, and also Latin America and the Caribbean. If you look at the map of legal actions, that's where most of the action is happening. So those are the regions where I would expect some of the challenges, legal challenges, that seek to close that gap between the law and policy to happen.
Could I just add something? I'm the only non-lawyer up here, but one interesting thing that our reporters found around the endangerment finding, and I'd be curious to hear from you guys about this, is that some of the major oil and gas companies, like the Exxons and Chevrons of the world, really did not want the endangerment finding pulled. And the reason is that, as you know, there's lots of lawsuits against the major oil and gas companies at the local level, localities, counties, states, right? And the fight so far in the United States has been about where those cases should be adjudicated. Those cases have been filed in state court, and the major oil companies have said climate change is a federal issue. This needs to be decided in federal court. So far, they've been losing on that, but they continue to push that argument. So they didn't want the endangerment finding pulled, because then if you get rid of a federal level determination about regulating climate change, right, then it makes your argument as the defendants in these cases weaker about venue. That, you know, if the federal government is no longer regulating climate pollution, then, you know, then this can go to the states, right? Then the localities that are suing have more of an argument to pursue those cases on the state level. Does that make sense? I mean, is that what you're hearing too? That's what we were hearing.
Yes, it does make sense, and I'm hearing that too, mostly because I'm hearing it from you.
I thought our reporters called you to get that. So.
Well, maybe it's all related. But yeah, it does make sense. The issues are actually pretty complicated. I think it is true that a lot of fossil fuel companies would like to keep the endangerment finding in place, and I think lobbied the administration to do that. What they wanted was to keep the endangerment finding in place and to significantly weaken the standards, so they did virtually nothing, but they would continue preempting state actions. And here there are basically two different buckets. I mean, one is the power plant bucket, and the other is the vehicle bucket. And the legal issues are actually pretty different. In the power plant bucket, these federal common law actions that you referred to cannot be brought as long as the federal government has the authority under the Clean Air Act to regulate the greenhouse gas emissions of power plants. In the vehicle bucket, the issue is that under the Clean Air Act, California can set more stringent standards than the federal standards if it gets an EPA waiver for air pollutants. But if greenhouse gases aren't air pollutants, it's not clear there's any bar on what California can do under the Clean Air Act, and it could set more stringent vehicle standards. But there's a different problem, which is that there's also regulatory authority in NHTSA, which is part of the Department of Transportation, and it's possible that those standards could preempt California generally. I mean, those issues are like hugely complicated. And the administration is making the argument, I mean, it's sort of suggesting in the final rule, repealing the vehicle standards, that its view as a preemption would remain. I think that's going to be like another round of contesting. And it suggested the same in the proposal to repeal the power plant standards back in the summer. So I think this is like something coming down the pike. I think the reason the fossil fuel companies are worried is because there's going to be lots of litigation uncertainty around it. I don't think they know how this is all going to turn out. I don't think anyone completely knows how those cases are going to work out. But I think it is the case that if EPA follows what it did on vehicles with what it apparently intends to do on power plants, on both fronts there's going to be a lot of litigation on preemption issues.
Mm-hmm. So, Ricky, let me maybe ask you this question, which is, although the administration's legal arguments are very poor, C+ perhaps, or D on a law school exam, okay, that doesn't necessarily mean that they might not succeed in court. And so I'm curious how you think about how the administration might fare in court, assuming on the rescission of the endangerment finding, assuming this goes to the Supreme Court. And I guess I wanted to also ask you about the potential that some of the coverage has flagged that there might be a risk for environmentalists or blue state attorney generals in going to the Supreme Court, which is that there's this potential that if you get a Supreme Court ruling that basically says there's no authority, as the administration is arguing, to regulate greenhouse gas emissions under the Clean Air Act, then that would foreclose a future administration from also regulating under the Clean Air Act. So what's your assessment of how the administration is likely to fare in court, and then also are there risks from the environmentalist side in taking these issues all the way to the Supreme Court?
I don't think that environmental groups are going to take the issue to the Supreme Court. I think it's going to, if it ends up in the Supreme Court, the path will be different. This case will get litigated initially in the DC Circuit. Actually, petitions for review were filed yesterday by the consortium of environmental groups. And there's exclusive venue in the DC Circuit. There's no question this case will get litigated initially in the DC Circuit. I am confident that the administration will lose in the DC Circuit, in part because, its best argument is, the argument that somehow rather its position can live alongside Massachusetts EPA is really a frivolous position. If sanctions could be imposed in challenges to agency action, which I don't think they can, it should be a sanctionable argument. Maybe the administration will eventually ask the Supreme Court to overrule Massachusetts EPA. That's possible. The DC Circuit doesn't have the authority to do that. So it can never be 100% certain, but, I would assign a probability of over 95% that the administration is going to lose in the DC Circuit. So then, no environmental group or attorneys general for blue states is going to take this case to the Supreme Court. They will have won. This case will then be taken to the Supreme Court by the administration. And they will certainly file a petition in the Supreme Court. The Supreme Court might grant the petition. How do I think it will fare? Well, look, the Supreme Court has been very hostile to regulation of the Clean Air Act, and especially the greenhouse gas regulation of the Clean Air Act. On the other hand, what it would have to be asked to do is a very big deal, because it's not just overruling one case. It would have to overrule probably 4 cases, including some that are more recent. And that might be a heavier lift. And it would have to do that on arguments that are really bad. So I won't assign probabilities there, and if I did, it probably wouldn't be 95%. But, I have to be kind of reasonably confident that even a judge who's generally hostile to environmental regulation, taking a fair look at the arguments, would conclude that the administration's position can't stand. I think something that should not happen is that no one should seek preliminary relief in the DC Circuit against this rule, because if that happened, this case will get to the Supreme Court early, and it will get to the Supreme Court without what I'm pretty confident will be a favorable DC Circuit opinion. This might also take a while to work itself out. It is quite possible that by the time the Supreme Court is in a position to even decide this case, that there'll be a different administration in office, in which case this litigation will be put to an end and will never get decided. So I don't think it would be a hard question whether to just give up on this now, which would be very difficult because it would be very hard for a new administration to put it back together, or potentially risk a bad decision in the Supreme Court. But I don't think it's going to work out that way. I think it's the administration that's going to seek the opinion of the Supreme Court, and I'm cautiously optimistic that the really egregiously poor quality of the legal arguments will carry the day in the Supreme Court.
So, Jake, going back to you, one interesting thing that the EU has done is try to use trade policy to address climate change, and also to kind of encourage other countries to address climate change. And so the EU is gradually implementing its carbon border adjustment mechanism, which basically imposes a price on goods imported into the EU that don't face a kind of comparable price in their own domestic setting. And so I'm curious what you think the effect of CBAM has been. And partly I ask this because, notwithstanding all the rollbacks we've seen here, both at the regulatory level and the rollbacks of the Inflation Reduction Act, one interesting thing that Recently, in an appropriations bill, Congress ordered the Department of Energy to do this study to basically prove that the carbon intensity of certain U.S. goods that could be captured by CBAM was pretty low. And in other words, that they shouldn't really be heavily charged under CBAM. So one might argue that CBAM is, to some extent, having a little bit of an effect in the U.S. context. So I'm curious how do you think CBAM is faring, and does what you're seeing with CBAM suggest that trade policy could be a lever to be used in this period of retrenchment in a number of major economies in addressing climate change?
Yeah. I mean, CBAM has attracted a lot of attention for reasons that I'll get into in a moment, but in fact, it's just only one of a series of trade-related climate measures that the EU has put in place in order to achieve our objectives of decarbonizing our own economy, but also leveling the playing field with regard to those that aren't acting as much to reduce their emissions. So there is the European Union's deforestation regulation that basically puts in place standards to ensure that agricultural and forestry products that are being imported in the EU meet certain sustainability standards, including with regard to their carbon footprint. And there are more and more regulations that are being placed on the market in the EU that will ensure a low carbon footprint for products that are entering the European market. The CBAM, I spent a lot of time defending it as a point of principle at the international level, and I can say that the opposition to it on a point of principle has been quite fierce, right? It's perceived by many, particularly of our developing country partners, as being unilateral in its character. They see it as setting standards that are based on European standards and not taking into account that many developing countries have higher emissions because they have different priorities. They've got to meet their basic energy needs. And there's no adjustment with regard to the source of the product that a price is being applied to take into account the level of development. It's designed in that way because it's focused on emissions and not on development priorities, and because it's been designed consistent with our obligations under the WTO to respect the most favored nation non-discrimination principle. But it has been controversial at a political and a principled level. However, we do see it having this encouraging effect on third countries to put in place their own carbon pricing policies, for the obvious logical reason that if they're going to have to pay, someone's going to have to pay a price for the carbon embedded in their product, wouldn't it be better that that price goes to their own domestic economy, to their own government, rather than the price being charged by the EU and going into the EU coffers? So we're seeing more carbon pricing, and very interestingly, we're seeing more jurisdictions that are putting in place a carbon price also thinking about a carbon border adjustment mechanism to level the playing field in terms of the prices that their own domestic producers are paying, but also to prevent what's called carbon leakage. The higher the price that you pay for producing carbon-intensive products at home, the more there is a risk that your consumers will look for lower-cost products coming from countries with lower standards, therefore leading to a growth of emissions, which is exactly the opposite of what your policy is designed to achieve. So a carbon border adjustment mechanism helps with that as well. And we're seeing these policies emerging not just in other classically developed countries. The UK is putting one in place a year later than the EU. Australia is currently contemplating one as well, but also in developing countries as well. Brazil, under the Lula administration, has just agreed an economy-wide emissions trading system, and within that lies the potential for a carbon border adjustment mechanism within the legislation as well. So jurisdictions like the United States, I guess, are contemplating a possible scenario where even if the US isn't putting these kinds of policies in place, their trading partners will and are. In those circumstances, they may want to be able to demonstrate that, for example, methane or steel that's being exported from the United States has a lower carbon footprint than steel or methane coming from the Middle East or from China, to gain a kind of a commercial advantage in that context, even if the motivation has nothing to do with avoiding greenhouse gas emissions. And you often hear this administration and previous administrations, whether they were to the left or the right, claiming that for a variety of reasons, US products are cleaner than the products produced elsewhere. So it would be consistent with that kind of logic as well.
Can I ask a question, Jake? What does it mean to apply CBAM to the United States when the president, at his whim, can say, well, if you want to do that, we're going to impose 100% tariffs on all your products, and so no matter what the international legal order says?
Yeah, well, I mean, that's a much bigger problem. It doesn't seem that there is much that the EU can do that doesn't provoke that kind of response from this administration. So I think it's kind of at the margins of concerns about the potential retaliation in the form of tariffs or otherwise. But it starts to be applied this year. We haven't yet heard that kind of threat, maybe because it's so much at the margins, again, in terms of the size of the trading relationship with the EU. It's relatively minor, but it wouldn't surprise me if it came.
Mm-hmm.
But the other side of it is, I think it's likely that CBAM would be considered a very attractive policy mechanism for the next Democratic administration. And if the EU and the US both have such policies, could they really be effective and basically become the norm across the world?
Absolutely. And even if CBAMs doesn't become the norm, the idea that you are measuring the carbon embedded in traded products and applying policies to incentivize low carbon products and disincentivize high carbon products would be a very powerful alliance coming from the US, the size of the US economy and the size of the EU economy. I can't see the US putting in place a CBAM as the EU describes a CBAM, because that would, of course, require a carbon price being put in place in the US economy. And I think even under a Democratic administration, I'm told that might be a long shot.
There were Republicans under the previous administration, there were Republican members of Congress under the previous administration who were sponsoring legislation or co-sponsoring legislation, and mainly from the perspective of making American goods more competitive than, say, goods from China. But that's kind of gone away. So it could be one of those things that purely from a competitiveness standpoint could be, if there's a Democratic administration after 2028, it could be taken up again.
Yeah.
So, Neela, maybe this is a good time to ask you this, because whenever a conversation turns to CBAM, my eyes start to glaze over as we descend into jargon here. So my question was going to be, what are some of the challenges about covering climate change and sort of the complexity of it? And also there's, of course, this disagreement, at least in the US, about whether it exists or not. So how do you deal with some of the complexities as a journalist with covering this topic?
Right. So I think one of the things that we as journalists benefit from is that we have data, right, about what our audiences respond to. We have it, other media have it. And so we can see what resonates with our audiences, with NPR audiences. Typically, I think consumers of legacy media, including NPR, accept that human-caused climate change is real. There's been more and more polling now showing, beyond like the data that we get, our proprietary data, but like Yale and others have done polling among a broader cross-section of Americans, showing that there is increased concern that climate change is a problem. People are worried about extreme weather, and even I think smaller, like slim majorities, depending upon the poll, of Republicans, largely driven by younger Republicans, younger conservatives, see human-caused climate change as something that needs to be addressed. Now, their solutions versus what the left wants to do, or there's room for discussion there, but there's I feel like this notion that that people are not responsive to it, at least in the audience we have, and then the broader American society, is starting to erode, and it's not something that we really worry about with our reporting at NPR. That said, I think the bigger concern when you're a journalist on climate is that, oh my God, it's so depressing, I just want to curl up in a ball and I don't know, like watch Netflix or something. And here it's what we try to do is we look at the data and see what people respond to. People respond to science that kind of sums up where we are, right? What the risks are, what the window is for action. They respond to that. They respond to stories that fact check claims. Like one of the stories that we just did recently that was very popular, I was just looking at some data this morning, is that two of our reporters did a story about the fact that they want to restructure FEMA, right? And there's a council that is going to the president with recommendations on how to restructure FEMA. The report's been leaked, we got a copy, and we looked at the 3 biggest recommendations. So what we did was we went to emergency management experts, including former FEMA officials, and said, do these things make sense, right? Like, they want to devolve more responsibility to the states. Does that make sense? And so, people like it when there are competing claims and you help them with a way forward to understand what those competing claims mean. And I think that's something that journalists themselves enjoy doing. People appreciate news about or reporting about things that affect their lives. Like the stuff that we've done on home insurance really, really resonates with people. And that is, it doesn't matter whether you're a Republican or a Democrat. Like if your home insurance is going up or it's being dropped, like it really, it's freaking people out. And media across the board have written about it and will continue to write about it. And solutions really resonate with people. And finally, like accountability work really resonates with people, right? Like, you want to build utility scale solar, but it's not going up. Where's the playbook coming from that is being used in community after community to subvert utility scale solar, right? Because it's the same arguments, the same rhetoric. So we looked into where that came from. And so it's work like that. So, so we're definitely finding ways that climate change reporting resonates with people, and that keeps us going. It really does. I think a lot of times people ask you as a journalist, how can you do this day in and day out? And I feel like the reason we can do it is we have some place to put our questions, our anxieties, our frustration, and that is into reporting.
Cesar, in addition to working on climate change litigation, you've started in recent years to do work on more than human rights related to the rights of nature. And I'm curious in some way, just picking up on what Neela said about people respond to things that affect them in their immediate lives. Do you think that this sort of idea of recognizing rights in nature, is this in your mind, is this partly a strategy that maybe makes climate change more tangible in certain ways? And how do you see the relationship, say, between your work on the rights of nature and climate change? Is this potentially a strategy to help address climate change and create more momentum?
I'm really glad that Neela mentioned the need to concretize the stories and the impacts. That's been also our experience in advocacy and research and litigation. One thing, and we spent many years working with the Paris framework and with movements that really push hard to make the Paris framework work. For example, the youth climate activists who engaged with the negotiations and spent a lot of time and energy believing that would get us as humanity closer to 1.5 as the limit of global warming. As much as that type of activism has been fundamental to keeping the global public's attention centered on climate, its drawback is that it focuses on too abstract a target, right? No one really, like in the regular news, the average citizen is not quite motivated to act if what you tell them to do is to contribute to keeping global warming to 1.5. Now, if the ask is try to protect this forest, or look at how climate change is affecting your insurance cost and so on. That brings that abstract climate system idea down to earth, which is why I think that not only the rights of nature, but also biodiversity work does help advance climate action in many ways. One of the trends that I saw in studying climate litigation is that it became too much of a silo, that it became too much of a specialized world for climate litigation specialists to work on, and there would be little conversation with biodiversity experts, people who would go to the biodiversity CBD COPs, and that started to change in 2024, around the time of the Cali, Colombia Biodiversity COP, where some climate advocates and negotiators and biodiversity experts came together and said, well, can we not compare notes? Can we not do advanced ideas within the CBD framework that could also help us fight climate change? And that's where the rights of nature work and biodiversity research and advocacy have played a role. To your point, Katrina, I do think that, and I've seen this on the ground in places like Bangladesh, Ecuador, just recently New Zealand, people are hugely motivated to protect forests, to protect marine ecosystems, to protect specific species, whales, elephants, pets, whatever it is. And that resonates strongly with a message that climate activists can kind of tag on to when they also campaign for greater climate action. There's an interesting legal convergence happening around climate change and rights of nature, which was triggered by, at least in this part of the world, with the advisory opinion by the Inter-American Court. The Inter-American Court went far beyond what anyone had thought in terms of affirming the fact that the environment or nature deserves protection in and of itself, regardless of the interest of human beings in the protection of, say, a given ecosystem. After that decision, and even before that decision, a whole wave of litigation had been filed and had been pursued in courts and in legislatures in terms of legislative initiatives across Latin America. Now there's, if you look at the Eco-Justice Monitor, which is the academic hub that keeps track of rights of nature initiatives, there's more than 600 currently being advanced around the world. Of course, not all of them are successful, but just recently the Spanish Parliament passed a piece of legislation that protects a whole lagoon system as a subject of rights. The Constitutional Court of Spain reviewed the law and ruled in favor. So this is moving, just like climate litigation and rights-based climate litigation moved from the periphery to the mainstream over the last 20 years. I start seeing signs of this mainstreaming of the idea, and I do think that it has a lot of political potential.
Well, I mean, the funny thing is, the United States kind of lagging behind, like covering climate change for, I don't know, what is it, like 15 years now. It used to be that a lot of people would dismiss, a lot of Americans would dismiss climate change, in fact, as a problem of nature and not humanity, right? And now that they're seeing their impact on their health, especially, like so much science now is about climate change's impact on human health in the United States. Like it's, people are waking up to what's happening. All of the discussion around heat and the pushback that you're seeing, like the preemptive laws in states where, like in Texas and Florida, for example, where cities have tried to have heat standards to protect outdoor workers, and then you have the state legislatures weigh in to prevent municipalities from protecting workers, is so interesting because, like I said, I feel like the United States is lagging the rest of the world in understanding that this is a threat to human health, and that, and for a long time, it was like, people would be like, oh, well, climate change, polar bears, I mean, and it's not that anymore, and I'm feeling in, like, among regular people.
On that point, I think that's a crucial point, and extreme heat is one aspect, one type of impact of climate change that brings this all home. One additional advantage of extreme heat as a subject for journalistic coverage and also as an issue for advocacy and litigation is that science is a lot stronger on the impacts of extreme heat relative to other extreme weather events, floods, sea level rise. So the science is there. The people who suffer the consequences are very concrete. These are individuals and communities who are individuals in the farming industry, for example, who collapse after working in the open air for hours at a time without breaks or bathroom breaks or water breaks. So especially for those of us who have a human rights background, that level of concreteness and that type of direct impact can be an opportunity for making this present to the rest of the population, including courts and legislature.
So I think this is a good time to open it up for questions if people want to come to the mics and you have questions. And let me carry forth, though, just on the theme. Well, I'm hoping other people will come up, but let me ask a question here, picking up on what you were just discussing. So, Neela, in the first Trump administration, there was a lot of kind of ground-up opposition that opposition to the administration's rollbacks on climate that emerged kind of from the ground up, from the bottom up. And you saw, especially in the last 2 years, like 2018, 2019, and laws being passed at the local level and the state level and blue states to sort of, reduce climate change and so forth. And I'm curious, are you starting to see in your coverage kind of the emergence of kind of a lot more bottom-up opposition, kind of mobilized in a way to respond and to get state and local action in the face of what's going on at the federal level? Or is there something different about this period compared to the first Trump administration?
Well, I mean, I think certainly there's something different, and I think across the board, regardless of whatever policy you're talking about, like immigration, climate, that what surprised people is how fast this administration has moved and how aggressively, and so I think a lot of people were on the back foot. And I think they've gotten their bearings and they're seeing how they can proceed forward. The problem has been, though, like, say, for example, the loss of funds for communities to enact, programs to, say, bring, solar power to rural communities, or to cut emissions, or to help communities adapt. Like, that is being tied up in the courts, right? And so it's hard for a lot of those communities to proceed. So they're having to rethink, like, how are they going to get the funds to do those things, or is that going to be on ice forever? And I think that. That's the big difference, is that the administration's approach is different, and so people are trying to find different solutions, but I don't think people have given up. I mean, I don't get that sense at all. And I think the search for solutions continues, and often, I mean, what I think is interesting is, like, after, Trump at some point will leave office, and if there is a federal government that wants to partner with localities, will localities want to partner with them, right? Like, like, it's the same thing that I'm sure our allies overseas are asking, like, how reliable is any American government in the next generation as a partner on anything? So that may make, a lot of, like, on a very local level, make those communities look for solutions either to reduce emissions or to adapt to threat, something much more localized. And that's kind of what we're seeing percolate up.
Hi, I'm Josh. Thank you all for being here and talking through some of this. Neela, especially, I listen to NPR every morning when I walk
thank
here.
you.
So, thank you as well. It's great to see you. So something that I've been thinking about as well, and I know myself and a bunch of 1Ls here the last several weeks, signing our names on to work at all these firms that are probably, 10, 20, 100 times more likely to get an Exxon client than a Greenpeace client. Something that I've been thinking about for myself is, kind of this logic of it's easier to make change from the inside, and once you have a foot in the door, you can, like, make progress in that. But I haven't actually been in the arena. I don't know what that looks like. I don't know how to do that. I guess I'm wondering, from your perspective, what do you see as either advice or the role of, people like myself or other 1Ls who are in similar positions to, take a stand and make change on the right side of this fight?
Well, some thoughts. There is very aggressive litigation going on against Trump administration policies, and it's been quite successful. Actually, both on the funding side and the regulatory side is just starting, but my prediction is that it'll be successful. And obviously, there are lawyers doing that. There are two main groups that do it. One is a coalition of like 22 or 23 state attorneys general for what are blue states, effectively. And the second is a consortium of environmental public interest groups. So you can go to one of these groups and you can litigate. I mean, I mentioned earlier that the litigation against this Department of Energy climate panel was enormously successful and led the administration to actually drop a big prong of its repeal of endangerment finding. There will be another different administration in Washington, and the power, I mean, I spent 2 years in the federal government leading the Biden administration's regulatory policy. The power of what can be accomplished in the government is really extraordinary. And so I know some of you here have had experiences of that sort in the government. You know, I would urge you to consider that as well. I think there are lots of ways you can make a difference, and in some ways, it's an exciting time to do that because these issues are in so much flux that you know, lawyers can move the needle significantly.
I would agree with that. I think it's also important to note that even in the private sector, there are strong interests in transitioning away from fossil fuels as well, right? All the economics suggests that the demand for oil and gas is going to be declining over time as renewables show themselves as being the more cost-effective investment from an economic point of view. And so working with that side of commercial interests, I think is a worthwhile way of a lawyer spending their time and seeing some decent results emerging from that. I mean, the one message I think that we've gotten from the current administration that feels like an open door that should be pushed on is this idea of energy abundance. It's something that whether you were a poor developing country or you were a rich country trying to figure out how you maintain your grids in the context of increasing demands from data centers, you need more energy. And the economics of energy will be increasingly towards renewables and away from fossil fuels. So I think there are commercial interests that are worth working for in this context.
Hi, I'm also a 1L. My name is Tejas, and I'm going to try to avoid total pessimism. But coming up as a young environmentalist, there were goals that were put out there in international legislation and domestic that talked about net neutral by 2030, and that seemed so far away when it was 2012. But now it's very close, and it's hard to avoid the perception that there's a potential or capacity to take much greater drastic or dramatic action to achieve goals or put things in motion that might actually help us get to something close to 2030. But all that is possible very practically is such marginal advancements, and there's like 2 steps backwards, 2 steps forward, like how far can we really get? And is it possible to achieve a sort of like total victory, or is it just a kind of whatever mitigation we can achieve by whatever point possible? 2030 is so far gone. So that's like kind of a broad question, I'm sorry.
Yeah, no, we get that question a lot, all the time. You know, whether it's COP or anything else, like there are goals that we need to achieve as far as emissions reductions, and we are way far from that, right? And, you know, the Washington Post had a great story about how warm every year is getting and how that's surprising scientists. So that can be very pessimistic. The problem is, or not the problem, but like, you know, you look at that and you can be very pessimistic. But what I think a lot of climate scientists and lawyers and activists will tell you is that we don't have the luxury to curl up in a ball and do nothing. It is not an all or nothing thing, right? If you don't hit 1.5, you're not like, well, we didn't hit 1.5, let's just give up. Like, every little degree matters. It's sort of like, you know, if you get 103 degree temperature, right? You have a fever. Like, that's really high. That sucks, right? Are you going to be like, oh my God, that sucks. I'm not going to do anything. Like, you are going to fight to keep your temperature down. And that's basically the mentality, is that scientists will tell you over and over again, including people who are like weeping over, like, say, coral bleaching because that's their life's work, right? They're like, we cannot stop trying to bring emissions down. If the curve is not as steep as we need for it to happen to avoid the worst things, not doing anything will make it even worse, like beyond imagination. So I think that's the thing, is that even when the news is bad and it feels like there's not the political will, there's not the momentum to drive down emissions to keep human communities and ecologies safer, that every little inch matters, right? So even if the federal government isn't doing things, maybe localities are doing things. Even if, like, we just came out of COP, and I think this is very interesting. I'd like to hear Jacob's view on this. COP, what did it achieve? I don't know. But there was a group of countries, including European countries, who are like, yeah, maybe we need to find a way to pull away from fossil fuels. And if like Saudi Arabia and the United States and Russia are going to get in the way of this at COP, maybe we pull away and do something on our own. So that is what we keep hearing from scientists, because we're always talking to them. They're the ones whose life work is to witness this kind of misery, and none of them are stopping documenting this or calling for action on it.
Yeah, I'd like to add something to that. Couldn't agree more on the every tenth of a degree matters, and also kind of connect this question with the previous question, which is the benefit of zooming out and looking at the world as opposed to just this country. Of course, it is a major emitter. It matters for the rest of the world. But in terms of places to work in, and in terms of places to look at, the world is big. And there are many organizations, from Planet Earth through Earth Justice to the Climate Litigation Network, that are doing everything they can with organizations like the Union of Concerned Scientists in the US, similar scientific organizations, and we have worked with some of them, and they will tell you exactly what Nilan just said. So they will fight one project at a time, one coal plant at a time, and avoiding tipping points matters. Keeping the Amazon as a net carbon sink as opposed to an emitter matters. And it's sad, but the goal of 1.5 and the hard kind of targets of 2030 and so on are probably not going to be helpful anymore. And we just have to fight this one day at a time and one country at a time.
So I'd just like to get in one more question. You want to step up to the mic? Yeah, sorry.
Yeah, so I guess thank you so much for having this event. And I feel like in a time when, in the US especially, we're so focused on just like preserving democracy and the rule of law and fundamental rights, I feel like the conversation in many ways has shifted away from climate change, whether that's like in legislatures or people that are running for office. And I'm curious how you think we can kind of continue keeping focus on the importance of climate change, and if, as I believe and I assume you all do, that this still is a moment when we need to be talking about climate change. How do we do that, and how do we make the argument that we should do that?
I think it'll be a good time to do this. As soon as we get past the midterm elections, there'll begin to be intense focus on the 2028 presidential elections. Candidates will emerge, discussions of platforms will come up, and that will be a great time to try to formulate what attractive policies should be. And so instead, this dovetails with the argument, like, don't be discouraged, we have to keep doing this work, and there'll be a good window in which to do the work, starting just in a few months.
Great. Well, I think on that note, I'd really like to thank the panelists who came, and also all of you for coming out and participating in the discussion. Thank you.